Hi, my name is Brianna Belusic, and I'm an attorney here at Kliem Associates. It's very common for clients to come and see me when a loved one has passed away, and very often they have questions about what happens to any real property they may have owned when they passed. I'd like to talk to you today a little bit about how that ownership or title in their real property passes when a loved one passes away. In order to determine how title will pass, the most important question you have to ask is whether or not they had a will. Today I'll talk to you a little bit about what happens when they do have a will, and in my next video I'll talk about what happens when they don't. When a valid will has been executed, the will normally specifies a person who is to receive the property in question at their passing. In order to effectively transfer title to such a named beneficiary in the will must be admitted to probate. Generally speaking, so long as there's a will that is admitted to probate and the will names a beneficiary to the real property in question, title is considered to have passed to that beneficiary on the same day the property owner died. Usually, the will is admitted to probate in the county where the person lived when they passed away. This makes it important to pay attention to where the real property is located and where the person passed away, as it's not always the same place. In these instances, an executor's deed may be filed in the county public records where the real property is actually located. If an executor's deed is not filed, you can always obtain a certified copy of a will and file that in the county public records. Due to the number of pages that a will contains as opposed to the number of pages that an executor's deed contains, it's usually a cheaper option to file an executor's deed. This act ensures that a full picture of the title transfer can be obtained in that same county where the property is located, which becomes important if you ever wish to obtain a lien or a mortgage on the home or sell the property. Alternatively, if the only item left in a person's estate is the real property, and they also have a properly executed will that leaves the property to a specified person, you can simply probate the will as a muniment of title. This is similar to the normal probate process with a few less steps, so it saves you a little bit of money. The process is the same insofar that you will probate the will in the county where the person lived. However, there's no need for administration of the estate. So, just like a full probate of a person's estate, so long as there is a will that has been admitted to probate, title to the real property in question is deemed to have passed to the beneficiary the same day the person passed away. Any of the attorneys here at Kliem Associates can assist you with any part of the probate process and help make the process a little easier for you. We're also here to help you figure out the best way to effectively transfer title upon a loved one's passing. Feel free to call us. Thanks.